Hello, my name is Stephen Labiak, and welcome to week 13 on things about bankruptcy. This week we're going to talk about the state of marriage and bankruptcy. So what do I mean by the state of marriage? Well, one of the factors is on how bankruptcy can affect you is whether you're married or not. I know that may seem like a pretty straightforward answer. Are you married? But believe it or not, that seems to be one of the questions that tends to confuse people. There's a lot of myths about marriage. The most common you hear about is common law marriage. Not all states have common law marriage. California is the largest state in the union, and we do not have common law marriage, where that means that you can be living with somebody, acting as husband and wife for 50 years, and you don't have the legal document that says you're married. As recognized by your county clerk, by the courts, by a priest, or however you do it, driving through in Vegas, doesn't matter. If it doesn't say that you're legally married, you are not married. And it works the same way for divorce. If you are married to that person, and you haven't been living together for 50 years, you are still legally married. Now, why does that affect bankruptcy? Well, if you're not married in bankruptcy and you're just living with somebody, that means that you guys cannot file together as a husband and wife. So that means it's going to be two separate bankruptcy cases. Why that matters is, quite frankly, is you're going to have to do it twice. You're going to have to pay twice. I don't recommend getting married for the sake of filing bankruptcy, but it's just something you need to be aware of. So what you don't want to have happen is you tell them you're married, you're not married. 5 years later, somebody finds out, they sue you, end up having to pay the debts, and you're going to end up spending a lot more on your legal bills than if you were just honest up front. Now, let's take it the other direction, that if you thought that you weren't married, but you were legally still married, it also can create problems. First off, in California, we've discussed previously the two exemption routes. If you're married and you do not have what's called a spousal waiver, you can only take what's called the 704 exemptions. The 704 exemptions deal basically with home equity. That means you don't have a $23,000 wild card to play with. If you get that spousal waiver signed by your spouse, however, you can use that $23,000 wild card exemption. Given the fact that a lot of property these days is now upside down, most people are taking the $23,000 wild card exemption, usually to protect taxes, vehicles, things like that. So if you thought you were, just because you didn't live with that person, well, I'm not married, well, no, the bankruptcy court would consider you married, and if you did not get that spousal waiver and you just filed as you were single and somebody found out, guess what happens? They reopen your bankruptcy case, they can revoke your discharge, they can come ask you to pay more money, all of those things. So that's why it's important to understand if you're married. So if you have any questions about this or any other topics about bankruptcy, feel free to give me a call at area code 559-274-2868. Thank you.